PoliticsJOE recently hosted an interview with Freddie Feltham, an ex-Labour Party staffer and host of the What's Left podcast. Freddie put forward several critiques of the European Convention on Human Rights from what he considers to be a left-wing perspective. In this video, I'm going to argue that there's no such thing as a left-wing case against the ECHR. While many of the arguments made by Freddie sound like they're coming from a sensible position, in reality they are far more damaging to the convention than he thinks. And not only that, his suggestions for reform are doomed to fail. Why? Because when it comes to the ECHR debate in the UK, we're dealing with vibes, not with facts. Rather than me summarise Freddie's argument, I'll let him speak for himself.
Part of the reason why people think that we're like mental open border people is because they hear about that Brazilian guy who was a child rapist in Brazil, who escaped being sentenced, came to this country, committed, was a paedophile here, and then they can't deport him because of the states of Brazilian jails. Like, I'm sorry, that is just insane. Like, if that person is resisting being deported because of invoking the ECHR, that is why we're losing people, some normal, sensible people on the lines of immigration who aren't racist. People want to be able to deport those people, and I agree with them.
Okay. Now, this is just one 30-second clip from a 15-minute video. I'll leave a link to the whole video below. But I think it's a good representation of Freddie's essential position. That ordinary people hearing that the European Court of Human Rights stops rapists and paedophiles from being deported is damaging the left, as the left supporting the ECHR is basically making us sound like we support paedophiles. Now, I'm not going to get into the specific case that Freddie is talking about, because I think it's irrelevant. Rather, what matters is Freddie thinks that, firstly, changing the court's approach to the prohibition on inhuman and degrading treatment or punishment is no big deal. And secondly, if we are to do this, we would cut off much of the criticism of the ECHR. So I'm going to deal with these 2 points in turn. The idea that the court should be more willing to deport people even if they are at a real and substantial risk of inhuman and degrading treatment is far more serious than Freddie thinks it is. This prohibition stems from Article 3, and it is one of the very few absolute rights in the Convention. By absolute right, I mean one in which an interference with can never be justified. These can be contrasted with limited or qualified rights, which permit interferences either in certain limited circumstances or under more general circumstances, so long as the interference is found to be proportionate. The reason why Article 3 is an absolute right is essentially because torture and inhuman and degrading treatment is so abhorrent that everybody should be protected from it, regardless of their conduct. The protection stems from the very fact that we are human. It has nothing to do with our past actions. So if the court were to permit a victim's conduct to be taken into account when assessing whether they've been subjected to ill treatment or not, this would be to fundamentally undermine the nature of Article 3, and indeed the very foundations of international human rights, which is to protect the inherent dignity of the person. What this also means is that it should be irrelevant where this inhuman and degrading treatment or torture is likely to occur. This is why the European Court of Human Rights has interpreted Article 3 as prohibiting deportation to countries where there is a real and substantial risk that they will be subject to ill treatment that violates Article 3. The UK has tried to push back against this absolute protection before. After 9/11 and during the so-called War on Terror, the UK intervened in an Italian case to argue that the court should take a victim's suspected terrorist activity into account when assessing whether they could be deported. The UK therefore argued that the threat presented by the person to be deported must be a factor to be assessed in relation to the possibility and nature of the potential ill treatment. Thankfully, the European Court of Human Rights rejected this argument. And in hindsight, this rejection became even more important when the extent of the USA's extraordinary rendition and torture program became public.
We tortured some folks.
Many states around the world were complicit in this, and the non-refoulement principle, as it is called, is integral to preventing states from contracting out other states to do their dirty work for them. So Freddie is either unaware about this, or he's unconcerned about it. Regardless, I fail to see how any of this can somehow be interpreted as left-wing. The second claim that Freddie makes is that reform will cut off much of the criticism of the ECHR. The big mistake Freddie makes here is that he is assuming that much of the debate on the ECHR is rational and facts-based. For me, this misses the point completely, as there are actually two debates on the ECHR in the UK. There is the factual, technocratic debate, and there is the more emotive, irrational debate, and Freddie is trying to use legal facts and arguments to influence this emotional debate. So what's wrong with this? PoliticsJOE posted this interview around the same time as I wrote a blog on this very issue, which was published by the UK Constitutional Law Association. I'm going to quote from this post now, and I will leave a full link to the blog below. In this blog, I argue that this emotional debate actually has elements of what, believe it or not, professional wrestling calls kayfabe. Kayfabe is a term co-opted by professional wrestling as the idea of presenting staged performances as genuine or authentic. The wrestlers know that it's fake, the audience too know that it's fake, but everybody pretends that it's real. Even when the wrestler leaves the stage, they stay in character. They never break the charade. You never break kayfabe. An increasing number of scholars studying populism are turning to kayfabe as a lens through which to understand the current political zeitgeist. It gained particular purchase in the US, where its explanatory force lay in shining new light on the first term of Donald Trump. He himself is actually no stranger to the wrestling stage. Kayfabe allows politicians to ground reality in a fictional story of their own creation, rather than objective truth, and they deploy several tools and tactics to do so. These include the disregard of codes of conduct, the celebration of storytelling, the suspension of disbelief, mediated spectacles, the antagonistic division of relations into faces, good, and heels, bad, personalised relationships, and direct appeals from the performer to the audience, signifiers of brute force, limited reliance on persuasive abilities, and general stage presence. It is kayfabe that allows politicians like Suella Braverman to refer to a hurricane of migration, and explains Robert Jenrick's claims that the SAS kills rather than captures terrorists because the ECHR would just require their release. Kayfabe explains why Nigel Farage can claim to be reduced to tears over the claim that an individual wasn't deported because his son disliked chicken nuggets.
The other story on the front page of the Daily Telegraph, Mr. Farage, is concerning the failed deportation of an Albanian criminal who was found with £250,000 worth of criminal proceeds on his person. We couldn't deport him because his child only likes British chicken nuggets.
I know, and you read this stuff, you just want to cry. And this is all because of the incorporation of the European Convention on Human Rights into British law, which our judges rule on again and again and again.
Or even why Theresa May felt confident claiming that a person could not be deported because of their cat.
We all know the stories about the Human Rights Act. The illegal immigrant who cannot be deported because, and I am not making this up, because he had a pet cat.
In this kayfabe world, it matters not that many of these claims are demonstrably false. On the contrary, that's precisely the point. Such is the danger of the moment we live in, as rising authoritarianism capitalises on eroding democratic norms and practices. The intentional creation of the fictitious and insistence upon its reality,
I am not making this up,
never breaking kayfabe, becomes an expression of power. Lawyers and academics therefore find themselves in the difficult position of expending intellectual labour to make legal arguments rebutting these fictitious claims in a political climate where the truth of these claims is irrelevant. In short, we're stuck trying to reason people away from a view or belief they never reasoned themselves into to begin with. We are basically bringing facts to a vibes fight. So when those on the self-identified left of British politics, such as Freddie, seek to co-opt aspects of this rights hostility, kayfabe suggests that as a political strategy designed to win votes, this is doomed to fail. Kayfabe is co-constructed. It is not that audience believe that wrestling is real. They're not dupes. Rather, the audience participates as an actual contributor. They are integral to adding to the match's narrative and reifying the fiction. However, this also demands a degree of bona fides on the part of the performer. The performer must commit to the character. They must not break kayfabe. So when a human rights lawyer prime minister leads a charge against the ECHR, the audience is likely to see through it. Far from bona fide, it comes across as cynical and opportunistic. Rather than dissipating rights hostility, such moves merely add weight to the idea that human rights protection in the UK is unduly skewed in favour of the bad folk devil. And so the Overton window shifts. The big mistake Freddie is making, therefore, is that he thinks that reform of the ECHR will dissipate hostility towards the ECHR. On the contrary, I contend that it will only further add weight to the idea that there is something inherently wrong or broken with the convention. And this problem is further compounded when we have surrendered the very idea of human rights as universal and belonging to everybody regardless of who they are or what they have done, as Freddie has argued we should do by reforming the application of Article 3 in deportation cases. I fully admit that I don't have the full answer on how we can confront this kayfabe world of rights hostility. But I do think rather than make the left-wing case for capitulating to critiques of the ECHR, we should defend human rights on its own terms. If you're interested in reading more about this idea sketched out in this video and where human rights defenders should go from here, I've left a link in the blog below.